Welcome back, everybody, to Constructive Uncoupling, the podcast devoted to amicable divorces. I'm Judy Weigel, your host and amicable divorce expert. Why? Because that's all I do, amicable divorces. Today is part 2 of our interview with attorney Robyn Santucci. Part 1 was all about defining what an attorney does, how to use an attorney properly. Robyn was explaining how she interviews clients to see what their needs are and if she is the right person to service them. Today we're going to talk about the financial aspect of working with an attorney. It's expensive, but when you need an attorney, you need an attorney. And so we want to enlighten you and give you the information so that you can understand how to manage your finances properly and let the attorney work for you properly as well. Robyn, welcome back.
Thank you, Judy. Happy to be here.
So, Robyn, there are various ways to use an attorney. So let's do the fullest way to maybe some individual ways to use an attorney in a divorce.
So the fullest way, that would be to have an attorney represent you in the divorce. So if that's what you want to do, because that's what you feel you need, you can hire an attorney. They will be attorney of record, we call it, for you, which means everything they file with the court, their name will be on it, and they're responsible to, for example, if you get notice that you need to show up in court, they will be there. You're holding their time, essentially, because they are in your shoes. They are representing you face-to-face with the court. Not to say that you won't also, of course, want to attend any court proceeding in your matter, but the attorney really is responsible for driving the case. They oversee every paperwork that's prepared or filed for you. They consult with you about decisions on the case, about getting the factual background that they need. So, but when you have a full representation, which is what I would call the whole enchilada, that attorney is really doing everything in your case in collaboration with you that's going to give them the facts that they need. So that would be, and be thinking of it also as probably the most expensive option because that it's much more time intensive. Also, like I said, they're going to need to show up in court if you get notice on 24 hours that the opposing party in your case needs to seek ex parte notice, for example, and you have a very short notice window. Your attorney has to theoretically be available for that, even if you're not, right? So that's the full rep. Then you can scale that down to, say, have an attorney that is helping you prepare the documents in your case, consult with you, but you are your attorney. So when you look at a court pleading, even the initial paperwork that's filed, your name will be in the caption and you are self-represented or pro per or pro se. These are all synonyms for you are the one that the court's going to hold accountable in this particular lawsuit. Not to say that you can't consult as needed with an attorney. Or let's say you really don't need much attorney involvement. You consult with one at the very beginning of your case. You have questions in the middle, and you maybe want an attorney to look through things at the end, meaning the judgment, and you can just have an attorney work with you on an hourly basis as you need it. So that would be, of course, the least expensive on the spectrum.
So in terms of what it costs to hire attorneys in Los Angeles who are good, who specialize in family law, as opposed to having family law be one of the areas of law, you really want somebody who specializes. Would it be fair to say between $400 an hour and $750 an hour? Is that the range?
I think I would say that's the range, yeah.
Okay, and so when somebody wants to hire you for full representation, can you explain the retainer process and concept and how that works?
Sure. So if someone wants me to represent them in the divorce case or paternity case, whatever the case is, then I will construct an engagement letter, which will set forth the terms of our working relationship. Along with that, I will ask for a retainer. A retainer is just a monetary amount they're going to pay me in advance, and I'm going to hold in trust for them and then bill against it at an hourly rate on a monthly basis. giving them, of course, an itemized bill once a month so they can see exactly the work that was done. I bill, and many attorneys in family law bill, but not all, on tenth of an hour increments because the time is so expensive. We try to really, make sure for every 6 minutes that we spend on the case, that's what we bill for, and not a larger chunk of time. So that's one way to kind of keep the cost down. Some attorneys have a minimum billing increment for every phone call or every, letter that they write of a minimum 0.2. It just depends. I mean, you're going to find a lot of variations with the attorneys that you may meet in LA. But the concept is that you pay money in advance versus you pay when you receive the bill. So if you pay money in advance, we deduct that from what you've given us. We give you the bill, and when that's all used up, you replenish it.
Good. I'm glad you said that because sometimes people think, well, I just paid a retainer of $10,000 or $5,000. And they're asking for more.
Right.
So, but that's because the case keeps going on and on and on and on, right?
Right. That means that the original retainer was used up.
Yes. And can you please address the fact that you said it, but I want you to say it again. All the time used to include phone calls, making them, receiving them, emails, making them, receiving them, and reading them, actual creating of the work product, whatever the work product is, and driving to court back and forth.
Yes. So,
and the reason why is?
Well, most lawyers, hopefully, in their retainer agreement will spell this out explicitly, again, because the time is expensive and you need to know as a consumer exactly what you're paying for. So the retainer agreement or the engagement letter should be very explicit over what tasks are going to be billed for. So that's going to be all time, unless there are exclusions to it. And that would be for all, just as Judy said, all phone calls, all emails. And most of cases these days are conducted via electronic communication, text and email. So if you look at it from the lawyer's perspective, if we didn't bill for text and emails, this would be a huge part of our day and that we wouldn't be billing for, and a huge amount of work on each case that we would be excluding. That's really where the communication with our clients is usually, because in this world, you can quickly send an email or receive an email and get a lot done in the case. So a lot of the time is spent doing this kind of transmission of information through electronic means. So we bill for each email, we bill for each text. Of course, if we're just setting up a phone call or, trying to arrange something like that that's really administrative, then obviously that's not a value add to the case. That's just sort of an administrative thing that we won't bill for, even though it does take our time. It certainly does take our time. So, but that's kind of left up to the individual attorney. But like Judy said, it's going to be travel time. It's going to be phone calls. It's going to be, preparing pleadings. That's probably the most time intensive thing that we do if we go to court. So it's generally all time spent.
And really what I would like people to appreciate, understand, and appreciate is with each phone call, with each email, and with the work in the office to set it up, it's all expert knowledge. It's all what everybody went to school for. It's what you're hiring people to do, is give you information that you wouldn't get on your own. And the way we communicate is email and phone call. And so segueing into how can people manage their bills then?
Good question. Okay, manage, if not minimize, I would say. Because again, hiring a lawyer is not inexpensive, even at the lowest rate. Not that I would recommend that you should just shop only for the lowest rate. You need to find the best lawyer for you. You can minimize your lawyer's time in the way that you would logically minimize any person's time who's working for you. The more organized you can be, that will be a challenge given what you're going through in the divorce. But the more organized you can be with supplying the lawyer information that has been requested, either in writing from you or in a meeting with the lawyer or a list that's been sent to you, whatever it is, it's going to be very specific with what you need to give the lawyer in terms of the business part of the divorce. So that's going to be your disclosures. The disclosures are the bane of the existence of pretty much all of my clients, and painfully we must do them at the beginning and the end of every case. So if you don't know what disclosures are and you're at the beginning of divorce, you will know what they are. But it's essentially supplying information regarding assets, debts, income, and expenses to opposing party, to your spouse. You both must do it, and again, it has to be done twice. This is the kind of thing where you can really save a lot of money. If you are organized and get to your lawyer everything that's requested at the beginning, or maybe the second time. But when the lawyer has to get into reviewing drafts of things, still seeing missing information, then going back and contacting you again to ask, and this goes on 7, 8, 10 cycles, you can see how the time spent on something like that can really add up. You don't want to do that also because if there's a large gap in between the times, then information gets stale and people, have to refresh their recollection of even what they were working on. So, for example, if I'm working on a judgment for someone, which is the final document in the case, and I've asked for specific information that I need, I will oftentimes try to wait until I get everything from the client just so I can pick up that document once, implement everything that's been given to me, and then turn around the draft versus things that trickle in, I think, from clients. You don't want to do a trickling in. Unless you only owe a couple things, then you can trickle that in. But you don't want to send something 1 week and then 2 weeks later send another document. And you're creating a situation where you're expecting the lawyer to go back many, many times to the same document, and all that time adds up. So try to be, as I said, organized and efficient.
That was so important, what you just said about trickling in, because even on my end, which is less than what you do quite often because it's a little bit more amicable, I explain to people, please get me the forms only first. Let me make sure you fill them out completely, and then let's get the support documents to each form. The trickling in from my end, from Robyn's end, from any attorney's end, I would like to share with you, forces us to pull your file because we can't remember. There's so much information, so much delicate and important information with every single person's divorce that you want to be accurate when you're responding to your clients, which means if there's too many weeks or months between getting all of the information to any attorney you're working with, that means the attorney has to take more time reviewing the file to bring themselves back up to speed. And yes, that's how you can be helpful managing the money, because you're managing your attorney's time. So thank you for that. Now, how can the clients know when there are frivolous filings or frivolous work being done by the attorney? So can we first of all get clarity, Robyn, on what is essential to each case, a basic case, and what would be something unnecessary? I mean, this is tough. I know I can give examples, but you start.
What would be unnecessary in terms of a filing?
Right. Okay. So there are things called frivolous filing. So in the world of law, there are phenomenal attorneys like yourself, or you wouldn't be here, who are so ethical and want to do the best for their clients for the least amount of money, given that the least amount of money is going to be expensive unto itself. And then there are attorneys that know that clients are emotional, and they take advantage of that, and they file things that are unnecessary.
Okay, well, I can't really speak to those attorneys and what the thinking is on that. I guess from the consumer's perspective, going to court, period, is very costly because of the time that it takes. When you bill time, which is all we have to sell as lawyers,
knowledge. You have time and knowledge.
Well,
Go
that's
ahead.
Yes, that's what the time is. That's what it's distilled down into an hourly increment, years of schooling and experience and accreditations and right. So I think it's when we go to court, I think for most lawyers who do litigation, we go to court, we have to be prepared, has to be accurate. We go to win. doing a filing that is not necessary, where we're going to lose because it's, as Judy said, it's frivolous, or we're bringing something to the court's attention that is not a winner. I think that doesn't happen as much as the perception, because the first time that you don't win and you brought something that was unnecessary and your client's left holding the bill, that client's not going to stay with the lawyer, and the lawyer's probably not going to repeat that kind of conduct. You have to understand, in family law, there's a policy, a state policy that's enshrined in the family code that promotes settlement in family law cases specifically. So this is not the same as every other kind of civil lawsuit. This is in particular with a family case because of the emotional high stakes that you have. As I think I said last time, you have family that's essentially suing each other. You have a husband and a wife, or wife and wife, husband and husband, that are no longer wanting to be married. It's such a delicate thing, especially if they're children, that the state has a policy that the courts can then implement under a family code, where you can be sanctioned if you bring frivolous motions before the court. You can be sanctioned if you don't attempt to settle your case. And they, we can look to case law to see what kind of behavior is sanctionable conduct. But that really kind of puts a damper on just going to court every week on something that's not really meritorious, I would say. Again, because it's so expensive, that's another big lever on going to court frequently. I think times have really changed in that respect. I just don't see a lot of frivolous filings, which is not to say that you're going to win everything that you bring before the court. I think it's tough to be a family law judge, and they end up having to split the baby more than they would probably like to acknowledge.
Okay, well, I have a couple examples that I wanted to ask about because they do really come up a lot. Not only do I see them in my office sometimes, if I'm working with one per person and the other spouse is being represented by an attorney. I can't negotiate for or represent the spouse without an attorney. I can simply do their paperwork for them. And then when the negotiations have to start, they must negotiate on their own with their spouse's attorney. But the two things I see come through, in my opinion, a little too often, when it doesn't look like the assets available warrant it, and those two things are demand for production and form interrogatories. When do you know when these two things are really unnecessary? And sometimes they come in second and third requests.
So that is in the category of discovery. So let's just clarify. What I was talking about before were actual filings in court, where paperwork is filed, pleadings are filed, evidence is submitted, and the court will call both parties in for a hearing to make a judicial determination of an unresolved issue. What Judy's now talking about is discovery, which is more fact gathering in the case. So in terms of when it would be unnecessary, I guess, to send out discovery, formal discovery, like you said, if the assets really don't warrant it, if there are no assets, or support is not going to be paid from one person to the other, if custody is not in dispute. I mean, whenever you have a dispute, I think is when you start thinking about formal discovery. And my sense is that if you exchange disclosures, which give you, 75% of the information you're going to need, at least preliminarily, if you see things in those disclosures as a lawyer that you're reviewing that do not add up, because the disclosures only require, let's say, current statements. You see bank statements, you see perhaps bank balances and from somebody who's unemployed, and how this money, did it get here? Well, maybe that was from statements that were 6 months ago. Maybe I need to follow the trail to make sure the ins and outs are as they're being represented. Well, I can't do that with just the disclosure. So at that point, I'd send out a demand for documents, which may ask for documents for the last year, 2 year, 3 years. And that's just a formal way where I can compel the other person to give me the documents that will answer the holes that the disclosure has created. Form interrogatories, as they're called, form interrogatories, they're specifically for family law. They don't take time to draft. They're pre-printed. So not a lot of preparation time on the attorney that's propounding form interrogatories. It will take time to answer, but it gives you a lot of the basic information that you need about what the claims are in the case. So it's probably the lowest profile discovery you can do. I wouldn't say family law form interrogatories are really frivolous. They can give you a lot of information. They're not always necessary. Sometimes they don't give you enough information, so they're kind of a waste, especially how some people choose to answer them. But, I think it's probably tough for any pro per to be served with discovery and then try and figure out, what do I need to do here? When is this due? What is being requested? I don't have these documents in my possession. Some of the things they're asking for are pretty crazy. Some of the things are being requested are in the other person's possession. What is going on here? I think it's hard because that's a real legal specialty tool that a pro per workshop or a self-help center at the court's not going to educate you on how to respond correctly to in a code compliant way to discovery. So it's tough. I think you may want to consult with a lawyer if you get served with discovery.
I appreciate that. Another question. What are your options if you can't afford an attorney but really need one?
It's a tough question. Well, as we talked about at the beginning, a lot of lawyers will work on a limited scope basis. So however much of them you can afford, some will agree to work with you just that much and kind of meet you where your needs are. So you don't have to go for the full representation. If you need someone to represent you for various reasons, there can be a lot of different reasons, and you don't have the money for it, but either your spouse has the money or the community estate has the money, you can petition the court to have your spouse pay or for a portion of, contribute to, at least advance fees to you. For example, if you have a house that has equity in it and both of you, need to hire attorneys, but you don't have the cash flow available, you can take an equity line on the house if your spouse agrees, and both of you can take out money to hire lawyers. That's one way to do it. If you go to court and you are requesting, fees be advanced to you so you can hire an attorney or pay your existing attorney from your spouse, you have to have a basis for that. So there's many code sections in the family code that give you the ability to request from the court on a need and ability to pay, so your need and the other spouse's ability to pay status to get a fee award. Understand that it costs money to go to court to get those fees, number one. And number two, it's not going to be 100% of all of your fees. So when you start thinking about where to get money to pay a lawyer, you start thinking about loans. You start thinking about meeting from family members. Who can you ask? It's a great way to try to get on a short-term basis money from people, especially if you have sort of assets to secure that. You're going to be getting certain assets in the divorce that are tied up, but eventually you'll be able to pay back your parents or your aunt or whoever can, give you money provisionally to hire the attorney to actually get through the divorce.
This is really a very important point because there are so many situations that I see where the divorce is imminent. Maybe there's been a lot of control with the spouse who works and makes money over the spouse that maybe has stayed home and raised the children, and that spouse doesn't really know where to go, how to start. I don't even know how much money we really have. Mm-hmm. We have one bank account I draw off of, but I'm sure there's other bank accounts available. I don't know anything about them. And it's a real quandary. They just don't know that they actually do have options. If they are pretty sure there's money in the family, they just can't get their hands on it. They can, though, still go to an attorney initially and maybe just pay for an hour or two and get a really good consultation done, and then learn about how to proceed and get an attorney's services paid for by other options like what you just said. But I think this happens a lot.
Yes. I think, access to funds for attorney's fees is a tough, very tough. I think, you don't want to spend more in attorney's fees, obviously, than the estate is worth if you can avoid that. The one exception to that, I think, is custody, where you're not going to court to get, to preserve your access to your share of the community, but for protection of your kids. But definitely, the fees can add up. You need to be able to weigh that. And I think, if you can work with a lawyer, a lot of lawyers take credit cards. That's another way. A lot of times you can, get loans against your 401k to hire lawyers. There are ways to do it. None of them are you excited about, of course. But if you need, expert legal advice, or you need somebody to fight for you, then it's a great option. So
you simply have to find the money.
Yeah.
Because if you need an attorney, you need an attorney.
Agreed.
That's just really the way it is. And I do want to make a point here that mediators, I'm a mediator and a legal document assistant, mediators don't represent you. So there's a big misconception going on in the community of people who need family law services that I can get divorced by a mediator. Well, a mediator works on negotiating a settlement agreement between two parties, but one person doesn't hire one mediator and another person hires another mediator, and now you're both being represented by a mediator. That is not how mediators are used. I just needed to make that clear as well. There also are limited pro bono services or services with sliding scales downtown, right?
There are, yes. There, depending on what your circumstances are, there are two really prominent in Los Angeles nonprofit family law legal assistance, I guess you would say, agencies. One is Harriet Buhai Center for Family Law that I do pro bono work for. Periodically, as they need me, they'll call me to do court appearances. But they help only, a certain, I guess, income-based needy folks or people who have domestic violence. So that's sort of in their charter. They have pretty strict income requirements, low income requirements, I guess you'd say, to choose you, to work with you as a client. Whereas on the sliding scale basis, there's Levitt Quinn, which you may want to investigate, that works with you on a sliding scale. I don't know exactly what their charter says in terms of who they end up selecting, because, we have a lot of people in Los Angeles that need legal help, and it's a great option to pay what you can. But obviously they can't accept every single case that walks in their door either. So I would say figure out which one may apply to you if either of them does. And they're both good options for the people that they help.
Question. Do people with Levitt and Quinn or Harriet Buhai go to court, though? Or do they prepare everything out of court for the people to bring to court themselves?
So the Harriet Buhai, it depends. I think it both depends. They have lawyers for Harriet Buhai that practice family law, that file motions in court for their clients. And sometimes their clients go in and are self-represented at the hearing, and sometimes they get pro bono attorneys from their panel, like myself, to go in with their clients on a limited scope basis just to do the hearing, so they have representation at the actual hearing. With Levitt and Quinn, I think it's full representation over there, which is why they can't accept every person that comes in, because I don't think they have the bandwidth to do it. But I'm pretty sure, but I'm speaking out of turn, I'm not as educated about Levitt and Quinn as I am about Harriet Buhai.
Okay. How do you, this goes back to how can you determine whether work is being done that's not necessary to your case. And I guess sometimes it really comes down to, it just doesn't feel right. It just doesn't feel right. Wait a minute, was this really necessary? This isn't really what I asked for. And now we're in court and we agree on that. Why are we in court? I think just that kind of logic and observance, you don't have to know the law to know that you may feel overserved.
Okay. What can I say about feeling overserved? I guess for me, it's just important to stay aligned with your lawyer all the time. So because we, practice family law, have divorce cases. They're all different. No one is alike, but we do know kind of the writing on the wall when we see it and what is probably coming down the pike. And we can maybe advise you on options and say they each have, a cost associated with them. But it's important for us, because of our duty of advocacy, to give you the options and to advise you on what your rights are, versus for me to make the assumption, oh, this client doesn't want to pay for something like that, so I'm not even going to give them the option. That is not ethical. I mean, I have to be able to advise my client, here's what's happening in the case. These are your options. And you select the option, and then I confirm with you, this is the option you've selected. And this is what we're now going to do, and then I execute on it. I mean, it's that, you should have that kind of lockstep relationship with your lawyer. So you never get a bill where you're like, whoa, what is this crazy bill? Or how did I find myself in court and didn't even know I was going to be here?
I think that's excellent, what you just said. So giving the options, because you do have a duty to provide all of the information that would be helpful to them. And then they can choose. And then, I know you well enough to know you would probably say, if that's what you choose, but this is what you're setting yourself up for that may not be so good if we don't do this. And it's a hard decision. The client does, I guess, have the ability to make their own decisions, what they do and do not want to do. But then you have that risk of, well, okay, you're taking the authority now. And if you want to take the authority, you have to take the responsibility that comes along with the authority if things don't work as well as you thought. Is that kind of the thinking?
You mean if the outcome in court?
The outcome isn't exactly what you want. And what do you do if you think your clients are making absolutely the wrong decision? Do you excuse yourself from the case? How do you, because this is going to be part and parcel of how does a client leave an attorney properly? So how do you each leave the case?
If I think the client's making a mistake, that happens a lot. That's not my call, though. I can only advise them on the upside and the downside of what potentially of the decisions that you're making. But people make their own choices as well. They should. It's their case, not mine. And, I'm not going to be putting myself into a position where I'm, creating an ethical problem for myself. That I would definitely get out of the case on. But if it's just should we do this in an aggressive way or should we be passive about it? Call it enough? Should we compromise on this? Should we go to court on this? That's all within the client's purview to make those decisions. And if I think, gosh, it's risky, but I understand why they want to do that, I'm 100% behind them. Just so long as I advise them on the risk and the potential rewards for doing it.
Okay. How does a client properly end a relationship? And it doesn't even have to be badly. It's just, you've given me great service, Robyn. I think I can finish on my own now. But you're the attorney of record. You're on the court profile. How does that resolve itself?
So very easily. So you can just terminate the engagement, in writing by an email, and then the actual technical way to get yourself back to either representing yourself if you're the party or hiring a new lawyer, there's a form called the Substitution of Attorney form. And with that form, it's a one-pager. Your attorney of record will sign it and you will consent to the substitution. You sign it, and the substitution is either you as self-representing or you have hired another lawyer that you like better, basically. And then that advises the court, and they'll change the record so that they know who to contact in the future about your case.
Okay, and I want to put another footnote on that as well, because I will then get calls as either more so as a legal document assistant to finish the filing for a case. Judy, I have been working with a lawyer, but now I'm not. And I ask, have you filed a substitution of attorney? What is that? So I'm glad you brought that up. But I want to even say more, that nobody is allowed to talk to you if you're under a contract with an attorney. I can't jeopardize your attorney-client relationship by taking your call, having a conversation with you, and you're still being represented by an attorney. The other part of that is they want to get somebody else's take on their case.
Oh, yeah, definitely. Yeah, I mean, you want a second opinion. I think what can't be done is to say, what did your lawyer tell you? That's a waiver. But you can go to somebody and say, look, here's my situation. You know nothing else but the facts I'm giving you. What is your take? Lawyer number 2. And they can tell you what they think, have you considered XYZ? Or, oh, I'm surprised to hear that judge did that. Or, oh gosh, who's your spouse's lawyer? Okay, that makes sense. You can kind of get a different take, certainly, without formally leaving your current lawyer, if that's what you want to do. It's up to you.
All right. That's good to know. And lastly, as we are concluding, do you feel that an attorney might do their client a disservice by predicting the outcome of a case? And how do you handle that? Because everybody wants to know, well, what are my chances, right? How do you handle that question?
Right. So I think anybody that says they can predict the outcome of your case with any certainty, run when you hear that, because there are so many variables in every case, especially at the beginning of a case when you don't know exactly what the facts are, maybe with the assets, with the debts. You can't really make a projection based on a limited universe of facts about what the ultimate outcome will be. And that's in resolving the case through, alternate resolution, mediation, or just settlement conferences, or however you want to do that. Or if you go to court, certainly if you go to court, very hard to predict and project and what the judge is going to do. And, every retainer agreement that I've seen says, results are not guaranteed. And I think that's absolutely true. I think you are hiring a lawyer for the advice. The advice comes from years of experience of seeing similar cases and of applying law that continually comes down from the Court of Appeals every year and Supreme Court every year. So the body of law itself can change. And you want a lawyer that's going to stay current on that kind of stuff, a specialist in family law, like Judy said. But even those, they can't give you absolute certainty. They can give you their best estimate, their best guess with the limited universe of facts that they have about what the outcome of the case is going to be.
Excellent. Thank you. Robyn, you've been wonderful. You've given us so much of your time, so much of your wonderful experience and your heart. I just love that you are available to people.
Well, I'm happy to do it, Judy. This has been fun.
And you're so available that if people wanted to call you, how do they reach you?
So I'm in Century City, and you can look on my website to find all of my contact information. It's Robyn Santucci, Santucci Family Law. If you just Google that, you'll find it all. And just give me a call, or you can email me, and we can see about connecting about your case.
Would you please spell your name, though?
Absolutely. So it's Robyn, and then the last name is Santucci, which is Santucci.
Excellent. And please do call her. I absolutely love referring people to Robyn. I know she's going to handle everything perfectly. And just be nice, which we all need that when we're going through a stressful time. We need somebody to be nice.
We do.
And
yes.
thoughtful and good. So thank you so very much.
You're welcome.
You have been listening to Constructive Uncoupling, the podcast devoted to amicable divorces. I'm Judy Weigel, and if you are looking for a divorce mediator or a legal document assistant, you may certainly reach me at Judy at divorceresourceinc.com, Judy at divorceresourceinc.com, or my company. You may look me up on my website, divorceresourceinc.com. Thank you so much, and we will be back next week.